Hello everyone, I'm Dr. Swati, welcoming you in the global online platform. So today we are continuing our session of unit number 9 of legal aspect of a business, and here we are continuing with the 25 most expected MCQs, and with the help of these MCQs we will cover full syllabus of the unit number 9 with a rapid revision. And this is a part 2. In the part 1 we have also covered 25 questions, which is important for your examination perspective. And today we are also taking 25 more questions, and which will help you for your examination. Okay, so let's start. Before we start, I will quickly tell you about the global online. So today, the new batch going to be started from the 3rd of the June, and here you will get the complete course of the commerce and management, daily live lectures, recorded lectures, complete syllabus notes in the PDF format, and the full syllabus mock test. Okay, and more than 4,000 MCQ series with a detailed explanation, and PYQs with the explanations. Okay, and here you will get paper 1 is free of cost if you register yourself for the paper 2. And global online provided 20% discount on the fees, so that 8,000 you 8,000, yeah, you will get paper. If you register for paper 2, you will get paper 1 is free of cost over here. Okay, so the contact number given in your screen, so get in touch with this contact number. This is WhatsApp only. If you have any query, if you want any discounts or more discounts, so you can get in touch with this contact number, and it will help you for more. Okay, so how to download the global online? Yes, you go to Google Play Store, search the global online, and after that install it, and after register with your register number, and go to my course, select the whatever the course do you want. And once you select and once you paid for that course, then you will register for that course, and you will get all the materials in the proper PDF form folder. And in this PDF folder you will get a video lectures. Okay, and the files and the test series, mock test, and the material with a PDF format. You can download it in your mobile phone. Okay, so let's start with the first question of today. That is, dormant company offer excellent advantage to which one of the following? Okay, the option number 1, banker; option number 2, creditor; option number 3, shareholder; and option number 4, that is a promoter. So first of all, I'm asking you, that is, what is a dormant company? What is a dormant company? The company which is related to the your real estate. Okay, for example, real estate. Okay, so what the real estate, I'm giving you the example, and after that I will explain you what is a dormant company. What is happening in the real estate is they store anything, any material, any production related things? No, they are just transferring the property or the things from the one owner to another owner. So there is this kind of the company is a dormant company. Clear? Now, the dormant company offered an excellent advantage to which one of the following? Here, the question is talking about the where the dormant company is having the excellent advantage to whom? Either a banker, either a creditor, either a shareholder, either a promoter. So in the dormant company there is the bankers haven't any kind of advantages. Yes, having a small but not much advantage. Okay, not a creditor, not a shareholder. The promoter having a advantage in the dormant company, because it enables the promoter who seek to start a company for a future project. Okay, or hold or asset, okay, intellectual property rights without having any significant account transaction. And the one more thing, that is a dormant company, they run the trade, but they do not they do not require to maintain the accounts, daily accounts. Okay, they do not need to maintain their accounts. Okay, so to yield the benefit of the dormant company, the company need to file an application to the registration. Okay, so the registrar, okay, they have to do the application to the registrar. So the option number 4 is right over here. Now the next question, which is in your screen, let's mark it the question. This is the first question. Okay. Now the second question which is in your screen, that is which of the following company do not okay, falls under the preview of their dormant company. Okay. So here which kind of company is not to fall under the dormant company? Okay, the question is, so here option is one, private company, one person company, limited and unlimited company, public company, and the government company. So the dormant company is either a private company or a public company or a one person company. Okay, so the dormant companies either be a private company, either be a public company, and or either be a one person company. Okay, in the, so the option number one, private company is a dormant company. Yes, this comes under the dormant company. Okay, then the one person companies comes under the dormant company, and the public companies comes under dormant company. So the question is do not fall. Okay, so the, what is it? Here is no, it's actually, it's not do not, it's not having a do not option. Okay, it's not a do not, because these are the companies falls under the dominant company. Okay, so here the option is not up, not over here, so do come in the falls under the dominant company. So here the public, private company, one person company, and public company. So here is the answer A, B and D. A, B and D. So the option number 3 is right over here. Okay. Limited and limited, unlimited liability companies not comes under the dormant company, and the government companies also not comes under the dormant company. Clear? Yes. Now next, which one of the following, this is the third question, which one of the following nature of the business is suitable to the dormant company? Which kind of business? Okay, so I have already told you, that is option number one, shipping company business, manufacturing company, real estate company, or pharmaceutical business. Okay, so what is the right over here? Yes ma'am, the real estate company, because they do not store any kind of product. Okay, they are just transferring property from one state to another in another state, or the, like this, they are not actually they are doing the trade, but not, they do not need to maintain their account. Okay, so here is a real estate company is right answer. Now the fourth question. Okay, assertion is given in your, in this question, and the reason is also given. If a company get a status, if the company get a status of the dormant company, then it is the subject to less compliances. Whenever I use the word dormant company, you just click in your mind that is a real estate company. Okay, so you will get you will easily understand the question very well. Okay, so whenever I say dormant company, you just think about the real estate company. Okay, so once the if the company get a status of the dormant company, then it is a subject to less compliance in comparison to the active company. Okay, in active company means the company which hold their trade, and also they maintain their financial statement or the accounts. Okay, that these are companies are the active company. Okay, and the reason is given behind of that, that is it will help to save the compliances for inactive company when they become the dormant company under the section 455 of the Companies Act in 2013, as compared to Companies Act in 2009, Companies Act 1956. So here is the section is important, because the company is having a dominant company, or the companies are having the help to save the compliance of the inactive company, and when they become a dominant company. In case of a dominant company, the inactive company, the definition of the dominant company and inactive company is given in the section 45 of the Companies Act. Okay, and as compared to the in the Companies Act 1956, this is the old one. Okay, the act, and this is a new one. Clear? So the, what is the right answer for this question according to you? Yes, here you know that here, Here, if the company get a status of the dormant company, then it is a subject to less compliance. Okay, in comparison to active company, yes, ma'am, this is true, because an active company having a more compliance, they need to maintain their account, they give the report to their managers, and they prepare a well planned, whatever they plan, they have to implement it. So there is a less compliance, because there is a no need to prepare this kind of things in the dormant company. So A is right over here. Clear? What about the next one? Next one, that is, it will help to save the compliances of inactive company, and when they become a dormant company under this section. Yes, under the section 455, the Companies Act in 2013, the dormant company, the status of the dormant company help to save the compliances for the inactive company. So now, what is an inactive company and what is an active company? So the answer for this question I will tell you about then in another question I will tell you what is a inactive company, what is the difference between the dormant company and inactive company. So the option number, both the statement is also true, the assertion is also true, and the reason behind of that, because this is given the compliances of the dormant company. Okay, it's given and given in the section 455 and in the Companies Act 2013. So the A is also right and R is also correct, and we correctly explain because it is given in the section. Okay. So here, yes, here what is a dormant company? What is here? You know that what is a dormant company? If the company was trading but is no longer carry out any profit driven business and business activity, it is a dormant company. That's why they do not need to maintain the financial statement, their accounts. Okay, because they are not the intention behind of that, they not drive the profit. Okay, in that case, if it is decided to register company named is just having it for the future, it's for the future, protect the name. Okay, they're actually the company which is not active yet, but they are in the market, they are in the market just because of they want to protect their name, their goodwill in the company. They have to be stay in the market. That's why this is the company which is not active, but they still in the market. So it is an inactive company until it's decided to be something to do. Until they are not decided to do something, they just want to be attained in the so that is inactive. They are not actively present in the market, but they having a name. They just want to protect their name. Okay, so that is the inactive company. Okay. Yes, option number A is right. Now this is the fourth question. Now it is the fifth question. Clear? Now the assertion is also and the reason is also given. Assertion, provision is made to obtain the status of the dormant company for an inactive company. It does not trade. Yes, it is true. Yet it is true, ma'am, because a provision is made, because inactive companies means which do not carry their trade, there's inactive in the market. When the provision is made to obtain the status of the dormant company for an inactive company, in that case what happened, they do not do any kind of trade. Yes, ma'am, this is true. The reason behind of that which is given, that is dormant company does not trade but has a significant accounting transaction, isn't it? The dormant company does not trade. Yes, the dormant company does the trade. Okay, does the trade, but they do not maintain their accounting transaction. They do not do their accounting transaction. Okay, so the A is right over here. A is right, the assertion is right, correct, but what the reason is incorrect. Okay, so R is incorrect here, so the option number 3 is right. Clear? Yes. Now, this is the sixth question, that is, which one of the following does not fall in the domain of the objective of the Competition Act? Okay, in the till the fifth question we have completed the dormant company. Okay, yeah, I hope so you understand the dormant company. What is dormant company? What is what is a dormant company? What is their things they need to be in the dormant company. Okay, so this is the basic things. Okay, I don't think so. The more they lax in the question. Okay, just if I found anything else, so I will pick in the next video. Okay. Now this is a really important. That is the Competition Act 2002. Okay, I have put many questions from this side because the 100% I have a surety that they will ask the question from this side. Okay, so let's begin. Which one of the following does not fall? Just remember, not okay. Fall in the domain of the the objective of the domain. Domain means main. Okay, the consider the main objective. Okay, of the Competition Act in India. Not fall. Okay, Competition Act encourage a competition. Yes, ma'am. They encourage a competition. Now, the Competition Act is made because of they want to maintain the competition. Hell, they want to maintain the healthy competition in the market. This is the objective behind of the Competition Act. They want a competition, but a healthy competition. Okay, so they encourage a competition. Yes, ma'am. Second option, the prevent abuse of the dominant position. If someone abusing their dominant position in the market, in that case, this is a violation of the Competition Act 2022, because the Competition Act 2022 said that the competition will be having the good and healthy competition between all the marketers, between all the seller, or between all the producer. Okay, so if someone is abusing his dominant position, in that case, this is not a kind of the Competition Act. This is not considered in the Competition Act. Okay, like for example, railway. Okay, what railway is doing? Railway is doing the they're taking a price according to the status of the status of the traveler. Okay, so what is if someone going in the local, either we can say in the AC class, so the price is they are going in the same destination from the Nagpur till the Chhattisgarh, till, no, Durg. Okay, from the Nagpur to the Durg. Okay, so destination is same. Okay, distance is same, but the price of the compartment is a different. Okay, so what they are doing, they are using their dominant position because they are having many transport, but the convenient transport is a railway. Okay, so this is a, if anyone is abusing, so the railway is not comes under the Competition Act. Okay, now I don't know about the future. Okay, now the next one, that is prevent. The word is used, prevent. Yes, this is an competition. They want to prevent the abuse of the dominant position. Yes, ma'am. Clear. Then the statement third is given, that is prevent a monopolist right arises out of the intellectual property, and I will explain you later. And the fourth one, that is a regulate the merge and acquisition. Yes, they regulate the merge and acquisition because if someone have the more than 2000 crores, okay, or the I think 1 crore, sorry, 1 crore. Okay, 1 crore, more than 1000 crore. If the two companies are going to merge or acquire, they have to be registered. Okay, they have to be informed to the authority. Okay, so that's why the actually CCI, the Competition Commission of India, they have to inform to the CCI, Competition Commission of India, that either this will affect to the Competition Act, either is affect to the market competition. Okay, okay, in that case the regulate merge acquisition is also comes under the Competition Act 2022. Clear. Now the option number third is what is talking, the prevent monopolistic. You know what is the monopolistic, where the many sellers and many buyers. Okay, but the products are homogeneous. Products are heterogeneous. The products are different. Okay, nahi, there is a products are heterogeneous and they're having a product differentiation. No, this is not a. There is a product differentiation. So what is the product differentiation? Product differentiation means like a mobile. Okay. Whenever I word use, I'm using just whenever I use a dominant company, you have to keep in your mind is you are just click in your mind that is this is a real estate company. When you're using the product differentiation, you have to click in your mind mobile. So why mobile, ma'am? Because a mobile is having the different prices according to their price, according to their quality, according to their versions. Okay, according to their version. So here is a you're using the mobile is for calling or using the internet and for that. This is a basic need. But they differentiate their product or they differentiate their price. Okay, according to the version or according to the customer needs. So this is a monopolistic. Okay, this is a monopolistic. This is a product differentiation which is comes under the monopolistic. So prevent this monopolistic right arises out of intellectual property. So is this the competition act? They want to prevent it? No, they do not want to prevent it, because in the monopolistic rights, they have to be. I mean, they have to be maintain their intellectual property. Okay, the rights are against arises out of the intellectual property. They do not want to prevent it. They want to attend it. Okay, so the option number 3 is right over here. Now the question number 7. Clear? Question number 7, which one of the following issue are addressed by the Information IT Act? Okay, this is a really important IT Act 2002. So the issue is talking about the issue addressed by the IT Act. So what are the issues of the IT Act? The IT Acts, the legal recognition of the electronic document, the second redressal of the grievances. After that, the offense and contravention, and next one, that is a dispute of settlement. The option of the statement number E, the justice dispensation justice dispensation system for the cyber crime. Okay, so here what is the issue? First of all, what is the IT Act? IT Act is, that means the Information Technology Act. It's related to your computer. In simple word, it is your related to your computer. Yeah. So this act is applicable to the company because it is a technology. Okay. So it is related to the company that do the business in India, including the entity register in the country, and once the outsources. So here what is um the issue? Here we are discussing the issue related consider under the IT Act 2022. That is the like they having the issue related there. They are tempering the computer uh, source document, hacking the computer system, receiving a stolen computer or the communication device. Okay, using the another person password, cheating, scanning other, using the computer resources, act of cyber terrorism. So these kind of these are the issue which comes under the IT Act. And another one that's like publishing obscene information in online, publishing image containing sexual act. Okay, and the fail to maintain the record, fail to refusal or complain by the government order. Okay, refuse to decrypt data. Okay, securing access or protect the system, misrepresentation, corporate bodies. Okay, are liable for the sensitive information. So these are the issues of the information. So what is it? The statement is given, that is legal recognition of electronic document, redressal is a information system. Okay, then the B is redressal of grievances, C offense of contravention, D dispute settlement, and the justice dispensation system for the cybercrime. So here is the issue of the IT Act is, that is first legal recognition of electronic document. Where is it? Electronic things, technology, computer, these words is this is an issue. Okay, Then the redressal grievances is comes under the Consumer Act. Okay, and the offense and contravention is IT Act, is related to IT. Dispute settlement is also an consumer. Okay, and after that the justice dispensation system of the cyber crime. Okay, so is also comes under the issue of if IT Act. Okay, so the ACE, fourth one. Okay, so fourth one is right answer. Clear? Yes, fourth one. Let's move toward the eighth question. Here, what assertion is given again and the reason is given. The assertion is lien. Lien is a right to retain possession of a goods. This question is from the Sales of Goods Act. Okay, so the lien is a right to retain the possession of a goods and refuse to deliver them to the buyer until the price due in respect of them is paid or intended. So what is a lien? Lien is having a right to lien. Okay, right to lien means lien means you stay in your hand. Okay, you stay your possession, you retain the possession. Okay, retain the possession of a goods and refuse to deliver them to the buyer until the price is due. Yes, ma'am, this is a right to lien. So A is right over here. The reason is given: an unpaid seller is a possession of a goods sold in the entitled to exercise his lien on the goods where the goods has been sold without any stipulation as to credit. Okay, so here this is also true because this is a unpaid seller. Right to retain is for the unpaid seller. It's talking about the unpaid seller has a right to retain the possession if the buyer is not paid his money. Okay, so it is for the unpaid seller in the possession of a goods sold. Who sold the goods? Seller. So unpaid seller sold the goods until the exercise his lien on the goods, and where the goods has been sold without any stipulated credit, so he has a right of the right seller, right to lien. This is a right of the seller. So yes, option number one is right. That is A is also true and R is also true, and R is correctly explained the A. Clear? Now, limited liability partnership may be wound up by which one of the following? Okay, limited liability partnership is voluntarily. Limited liability she is wound up. It's talking about the wound up, okay, of the LLP. Okay, so voluntary they can wound up, or either by the registrar of if the firm fail to file annual return in the prescribed form for the with the registrar of the company within 60 days of 60 days of a closure. So from the registrar of the company within the 60 days, where is it is happened? Okay, companies within 60 days of the closure of the financial year. Statement number 3, that is by the tribunal established under the Companies Act 2013, and the fourth one, either voluntarily or by the tribunal established under the Companies Act 2013. So the I will tell you that is the LLP is wound up when either it by the voluntarily or by the tribunal. Okay, established under the section under the Companies Act. Okay, Companies Act 2013. So the option number 4 is right because it's either by the voluntarily or by the tribunal establishment. Okay, yes. Now, this is ninth question. Now it is the 10th. Okay. Now the arrangement of the following in the winding up a process of the company by the tribunal in chronological sequence. So okay, you have to arrange this arrange the steps or the process of the winding up in the chronological sequence. Okay, so the statement is given that the settlement of a settlement, the word is come settlement of the list of the contributors and the application of the asset submission of the report by the company liquidator, petition for the winding up, director of the tribunal, or report of the company liquidation, appointment of the company liquidator. So what is it? That is, they first think in case of winding up a process, the tribunal, the company has to first, they have to file the petition for the winding up of the company. The first step, that is petition for the winding up the company. So the option number C is yes. The option number C is first. So this is going to be cancel. So the third is right answer. Where after the petition, they have to appoint the liquidator. Okay. After appointment of the liquidator, what they submit a report. Okay. They have to submission of the report of the company liquidator, and after they submission the report, they go to the director. Okay, in the director for the tribunal report of the company, and lastly they settle. The word is come, that is the settlement of the list of the contributors and application of the assets. So the option number third is right over here. The first thing, that is in the case of winding up the company, they file a petition, and the last thing, that is the settlement of the list of the contribution. Okay, yes. Then next question, that is 11th question. Which one of the following are the tax category under the GST? You know that is a 5%, 12%, 18%, 28%, 18%. Okay, so here, what is it, right? 5%, ma'am, 12%, ma'am, and 20%. ACE. Option number third is right. Clear? Now, next. Now the matching pair is given, that is a delivery or mode of delivery given, and explanation of this. What is the actual delivery? Actual delivery means you're actually handovering, physically hand over the possession of the goods by the seller to the buyer. Okay, so this is an actual delivery. What is a delivery? The word is delivery is using. So delivery is the voluntarily delivering means your voluntary transfer the possession of a good from the seller to the buyer. Clear it? Now what is the symbolic? Now this is a really symbolic means you are not actually giving the product in the hands of the buyer. Okay, you just symbolically transferring the product. Okay, like a seller hand over the buyer the key of the go down. Okay, he actually what seller is giving in hand seller is just transferring, symbolically transfer the key to the go down. Okay, so this is a symbolical delivery. After that, the constructive delivery means that is an acknowledgement by the third party on behalf of at a disposable of the buyer. So actual, that is it, first, second, and fourth, then one and third. Okay, so second, fourth, first and third. So option number second is correct. Okay, yes. Now, which one of the following is not a privilege or the right of the holders in the due course? Okay, rights of the holders in the due course negotiable instrument act. The option one is trouble against them, is trouble against denying the signature or capacity of the prior party. Second is trouble against the denying the original validity of the instrument, is trouble against the denying the capacity of the payee to the endorser, and is trouble against the denying the genuineness of the validity of the payee's endowment. Okay, so what is the right for this question? That is, I will tell you first, I will tell you the answer. After that, I will going to explain you. That is option number 4. Now, what is the holder in due course? What is a holder in due course? Holder in due course means any person who consider become the possessor of, okay, possessor of promissory note. You know that negotiable instrument having the promissory note, okay. They also a bill of exchange, checks, okay, or you can say hundi. Okay, hundi, okay. So hundi here, so this is a hundi. Okay, so the not a privilege, okay, the not privilege right, or the not a right of the holder in due course, you know that, who consider become a possessor of the promissory note, bill of exchange, a negotiable instrument, he has called as a holder in due course. Okay, he hold the bills, negotiable instrument in the all due course. Okay, so what is not a right? So he has a right to struggle against the denying the signature or the capacity of the prior party. Yes, this is an right of the holder in due course. He can deny the signature capacity of priors in the party. Okay, he is also having the estoppel against the denying the original validity of instrument. Okay, he is also having the estoppel against the denying the capacity of the pay to instruments, and but the estoppel against the denying the genuineness or the validity of pay is not concerned. Now I will explain you one by one. That is the estoppel against the denying signature capacity prior party is for here. No endorser of the negotiable instrument shall and suit thereof by the subsequent holder by pertaining to deny the signature or the capacity of contract by any prior. Okay, so they do not have the endorser of, okay, they do not have the to uh, right to right to permit. Okay, permit permit the signature or the capacity of contract any prior notice to the holder in due course. Okay, clear. Now the what is the estoppel against the denying original validity and instrument? No maker of promissory note or no drawer of a bill of exchange or check, or no acceptors of a bill of exchange for the honor of a drawer shall in a suit thereon by the holder in due course be permitted by denying the validity of the instrument. If no maker in the promissory note, there is no, if the no maker, the original validity means that where the absence of the holder, absence of the maker, absence of the acceptor. Okay, so in that case he has a right to deny. Clear. Now the estoppel against the denying the capacity of the payer to endure. If the person, if the maker, if the acceptor of the negotiable instrument is having no capacity to do this that contra that things, in that case he has a right to deny the accept the capacity of the owner. So he has a right to deny. Okay, but if the things is genuine, if the things is valid, okay, in that case he has to accept it. Okay, so the option number 4 is right over here. Clear. Next question. Next question, which one of the following statement is correct regarding the Negotiable Instrument Act? The negotiable instrument, the first statement, the check is always drawn on banker. Second, the check is required to accept by the drawee. A bill of exchange can be drawn payable to the bearer on the demand. A promissory note contain the conditional promises to pay in the valid promises. So what is the correct for the Negotiable Instrument Act? In Negotiable Instrument Act, that means a check is always drawn on the banker. That is, you have to encash with in the bank. So the check is always drawn on the banker. This is correct regarding the Negotiable Instrument Act. Okay. So option number first is right over here. Now the next question which is in your screen, that is, which one of the following essential anti-competition agreement? What is it? Anti-competition agreement as per the Competition Act Act in India. So first is given the exclusive distribution agreement. Second, resale price maintenance, exclusive supply agreement, non-competent agreement, tie-in agreement. So what is the NT? What is essential for the anti-competition agreement as per the Competition Act in India? So in the anti-competition agreement, they have to be tie-up agreement. Okay, they have to. What are the conditions? You know that the Competition Act is for the making healthy competition in the market. Okay, but some condition where the Competition Act give the relaxation to the to someone in case of that is a anti-competitive agreement. They can make a the maker they can make a anti-competitive agreement in case they are in tying agreement. The agreement between the manufacturer and the distributor not to sell manufactured product at and above the price floor or below the price seal. Okay, so in that case this is a tie and agreement. Okay, so this is the first statement. This is in that case anti competition, the Competition Act 2022 is not applicable. Okay, so it comes under the anti competition agreement. Okay, so next one, that is the exclusive distribution or here the exclusive distribution, that means if the distributor or if the supplier or the manufacturer only supply or exclusively distribute to the particular person, they having a contract like this, so this is an also kind of anti competition. Okay, or exclusive supply, this is also same if they are supplying only to the one person, as it is in agreement, they have signed the agreement like this, so it is also an anti competition. Clear? Or resale price maintenance. Okay, so resale, in the resale price maintenance, the sell the goods with a condition on resale at a stipulated price. Okay, so like if you forfeit your share, in the case of forfeit of share, in case of redemption of share, there is an thing, the company has to be decided, or there is a provision for that. They do not they don't resale, they don't forfeit the share in the premium amount. So this is an anti competition agreement. Clear? So this is the resale price of price maintain. So what is A is correct, resale is correct, exclusive supply is correct, and the E is correct. What is about the D, ma'am? Non-compete agreement. No, if they are non-compete agreement, this is not any kind of anti-competition agreement. This is not included. Okay, so the A, B, C, E, the fourth one. Okay, the fourth one is right. Yes. Now next question, which one of the following is not valid as per the Limited Liability Partnership Act 2008? First statement is given, LLP shall maintain its book of account on double entry system and on the cash accrual basis. Second, LLP shall prepare a statement of the account and solvency of each financial year. Yes, every LLP should not file an annual return with the register of the company. And the fourth, every LLP is separate legal entity independent of its partner. So, what is LLP? The question is, what is LLP? The question is which is not valid. So what is the, when he asks about the non-valid thing, the option is given and you have to choose only one. In that case, you have to focus on the valid thing, which is valid for the limited liability. The which statement is you think is you predict that it will not be the valid statement for this statement. That's right, that answer will be the right for this question. Okay, so yeah, in this question we are just focusing on the valid things of the LLP. Okay, so let's start. That is LLP. The first statement, LLP shall maintain its book of account on the double entry system and on cash or accrual. Yes, ma'am, they maintain the account in double entry system or on the cash or accrual basis. Yes, they can. Now, the LLP shall prepare a statement of account and solvency of each financial year. Yes, ma'am. Yes, they have to maintain. They shall be. Or the fourth one, I will going to for fourth one. Every LLP is a separate legal entity in independence of its partner. Yes, this is and the feature. Okay, the LLP is separate legal entity and independent of its partner. Yes, this is also true. Now the third one, that is every LLP shall not file an annual return with the register of the company. They shall file. How it is possible they not file the annual returns with the register of the company? They have to file. Okay, so the option number 3 is not valid. Okay, it's not valid. Clear? Now, next question, if the information sought has been supplied by third party. Okay, by the third party, like a holder in due course is a third party, or it is treated as a confident by the third party. The third party must give a representation before the PIO, public initial offer, okay, in reply to notice issue to its within the how many days from the date of receipt of such notice. So the answer for this question, that is a 10 days, because this is a factual question. So what is question? If the information sought has been supplied by the third party, okay, if this information is supplied by the third party, or it is treated as a confidential by the third party, okay, they decided that you have to be, this is a confidential information, you have to, you do not disclose this information to anybody else. So this is information given to the third party, and the third party must give a representation before the PIO, okay, in the reply to the notice issue within how many days? If it is confidential, you must to be submit within the within 10 days. Clear? Now, yes, next question, which is matching pair. Yes, this is important. Okay, this is really important. Let's see, this is a legal Latin phrases and the description is given. First one, conscious ad idem. Conscious ad idem, crudo pro quo, and crudo pro quo, and quantum merit, and the caveat emptor. So this is a Latin word. So what is the meaning of this Latin word? The conscious of idem. Conscious, you know that now. What is the conscious? Consciousness is related to your mind. Okay, you can remember this, a conscious adadam is related to your mind, so that is meeting of mind. Clear? So A having a fourth. Clear? So here we get answer. Sorry. Now the quido pro quo. Pro quo, that means you are you're paying, or you are for you're getting something, you have to return something. So that is a quido is related to the something in return. Okay, that is a something in return. It is a quido pro quo. Okay, this is a B1. Now the quantum meritum. Okay, quantum merit. Quantum merit, when you sound it, it's like a quantum means something quantity, something money, okay, something earning, or meritum means as much as possible. So it is meritum means money, okay, you're earning, okay. So quantum means quantity, quantity, much quantity. So as much earned, okay, as much earned, okay. Clear the you know that the caveat emptor is nothing but a buyer behavior. Okay, the third one. So here it is. Here it is. Yes, the option number 2 is correct. Okay. Now the next question: who among the following are the identify as the key managerial personnel? Okay, key managerial personnel in Indian Company Act 2013. Clear? So the statement 1 is given, that is Chief Executive Officer, whole time director, company secretary, chief risk officer, and the manager. Here, who is a key manager personnel? That is a KMP. Who is a KMP? KMP, what is a KMP? First of all, what is a KMP? KMP is a group. Ma'am, KMP is a group. Yes, it is a key manager personnel. That means it is a group. It's a group of people. What kind of people? Group of people in charge of the company operation. They having a charge for the company operation. Okay, company operation, they are decided to make, they are responsible for the smoothing function of the company. Okay, and they are employee vested within a certain essential functions and role. They having that. Clear? So this is the KMP, that is key marginal personnel, is given in the Companies Act 2013. The section is comes under the section 2 subsection 51, that is 251. Clear? Now, who is the key personnel of the company? Okay, who is identified? So here is it, the Chief Executive Officer is the key person of the company. Okay, company secretary is also key person of the company. Whole time director is also having the, he can hold a position of the key holder of the company. Okay, chief risk not chief not risk chief chief financial officer is also a key person of personnel of the company. Okay, so these are the key person of the company. Clear? So what is the right answer? And the manager, yes, no, the manager, key managerial, the manager is also the key person of the company. Okay, so the A B C E, fourth one is the right one, right answer. The fourth is the right answer. Clear? Now I will tell you the who is not appointed as a key, who will be not appointed as a key managerial personnel. The persons, the people who having the, either he is a chief executive, either he is a whole time director, either is a company CS, either is a manager. If he attained his age of first one, age of 70, or maximum age is 70 and the minimum age is 21. Okay, if his age is more than 70 or less than 21, in that case he is not eligible for the key manager person. He is not comes under the groups of the key manager, KMP. The next one, that is if he is insolvent, if he is a unsound mind, in that case is also if he is a unsound mind, either he is a insolvent person. Okay, in that case also he is not a KMP. Okay, or he is suspended payment to the creditor anytime. Okay, he is suspended because he do not do the payment to his creditor at any time. Okay, in that case also, after that he is a convict for the offense by the court. Okay, he does any kind of crime. Okay, any kind of offense which is by the court. So in that case, or more than the and the sentences to the more than the 6 month period. Okay, either is having imprisonment more than the 6 month period, in that case also he will not be eligible for the KMP. So the age criteria for the sound, that means there his stable ability to do, or his criminal status is important. Okay, yes, option number 4 is right. Next question which is in your screen, that is the statement number 1, display of a goods. Display, what is it? Okay, display of a goods by the shopkeeper with a price mark as a them is not an offer, but it is not an offer. It is an invitation to the public to make an offer to the buy the goods. Yes, this is a invitation. This is true. Display of the goods by the shopkeeper with a price mark. Okay, when you go to the shop and you see there are the so many product, and what you see, as per your budget the tag is given. Okay, sorry, the tag is given and the price is given in that tag. So as per your budget you purchase it. So it is an invitation, there is not an offer. There is an invitation to the public to make an offer. Yes ma'am, this is true. Second statement, price quotation, catalogs, advertisement is in a newspaper for a sale of an article do constitute a valid offer. No, it's not a offer. It's also an invitation, because it is a quotation, catalogs, advertisement is give the information of the product. Okay, so this is not an the advertisement is usually not a consider as a offer to enter into the contract. Okay, so this is an offer. It's the advertisement is not offering you, they're just giving the information to you. Clear? Instead is instead of the offer, if we use the information, in that case it will be true, but for this statement it is not a true. So statement number 1 is correct and second is incorrect. Option number 3 is correct. Okay, next one. Yes, we have done over here, and we will here we have completed the 25 questions. No, I have more. No, sorry. We have more. We not completed over here. Yes. In case of a warranty, the buyer can. In case of warranty, the buyer can in case of warranty. So what is the difference between the warranty? Main difference, okay? Warranty and the guarantee. You know that if anything, I'll write a wrong spelling, okay? Guarantee, okay? Guarantee. So what is a warranty and what is the guarantee? In the guarantee, you can return your product. Okay, you can return your product. What is in case of in the warranty, you cannot return your product. Only the damage is going to be claimed. Okay, damage going to be claimed. So in that case, which is right for the warranty, repeated the contract, no. Okay, the return the goods is it's a kind of a guarantee. Okay, guarantee. Refuse to pay the price. Refuse to pay the price is also a guarantee. Okay, if I am not fulfill this condition, you cannot pay. So this is a guarantee. Okay, but claim the damage only. This is a warranty. Clear? So option number 2, return of goods. No, this is wrongly done. Okay, in case of a warranty, the buyer claim only the damage. Okay, so the option number 2 is correct. This is wrong. Return the goods. Yeah, in return the goods is a guarantee, na? There is a guarantee you can return the goods within the 3 days. So this is a guarantee, but warranty only include the claim damage. Okay. Now, which one of the following company cannot be a small company? Which one of the following is cannot be a small company? A holding company, subsidiary company. Okay, what is about a small company? Two is a small company. Small company only having the one person. In simple word, a one person. Okay, simple word. One person. This is a small company. Holding company, subsidiary company. These are the big company. Okay, the company registered under the section 8 is also the company who registered under the section 8 is the company is also a big company. Okay, now the company or corporate body governed by the special act, so it is also it is also and not big company. One person company, yes, it is a small company. This question is about cannot be a small company. So the A, B, C is not a small company because they are a big company. A, B, C. Option number 2. Clear? Now, which one of the following duty is not? Again, not. Is not a generally duty of the director. Duty of the director. Duty of a good faith in order to promote the objective of the company. Yes, it is a duty of the director. Then general duty. You know that the director having a two kinds of duty. First one, spatial, not spatial, statutory and the general, general duty. Okay, so for the general duty, so not a general duty. Okay, so I will explain you first what is the general duty and what is the statutory duty. Statutory duty, the duty like to file a return. Okay, to file a return of allotment. Okay, then it's the like not is the issue the redeemable preference share or the redeemable after the 20, to disclose the interest. Okay, this is a duty to disclose the receipt from transfer of the property. This is this is an duty of the director. And to disclose the receipt of the compensation from the transfer of the share. Duty to attend the board meeting. Okay, this is duty to attend the board meeting. This is a statutory duty. Okay, to convene the statutory annual general meeting, extraordinary general meeting. This is a statutory. Then prepare and place the at the AGM. Okay, annual general meeting along with the balance sheet and the profit and loss account report, affair including the report of the board and the authentic and approval financial statement, and the appointment to the first auditor of the company, appointment the cost auditor of the company to make a declaration of the solvency. So this is a statutory because this is a basic things the important and basic thing they have to do. What is about the general duty? General duty, that means which is when you read the general duty, so you can say this is a moral thing which is already inbuilt in the director. So duty of a good faith. This is a general. Yes, they have to do the work in the company in the good faith. This is a general. Duty to due or reasonable care, skill, diligence, or the shall exercise the independent judgment. So this is a general. Is everyone having? It's not related to only the director. It is general to all the person. Yes. Now, duty not to delegate the assigned for the office assignment. So this is an also a general. Okay. Now, third one, due to attend the board meeting. This is a statutory, no? This is a statutory things they have to do in their company. Okay, so that's why the option number D is right over here. Yes. Now the next question: arrange the following process of the of making the contract in the chronological order. With the process of making the contract. Yes, this is an important. Yes, you know that this is a simple, but this is an important. Yes. So how to do it without reading the option, I will tell you. There is, yes, I will read the question statement, that is agreement, promise, offer, and proposal, contract, and acceptance. How do you remind it? Okay, your in comes in a contract, like a marriage. Okay, like a love. This is these things you will understand very in deep. Okay, so for the love at the first time, what do? You offer a girl or offer a boy, or you make a proposal. Okay, that I love you. Okay, and after that what happened? Either she accept, either she reject. Once they accept, once she accept, or once he accept, what happened? It become a promise. That means they comes under the promise. Okay, and once after the promise, they having a, if there is a consideration means in the law there is no consideration, but there is a consideration to take care of her. There are like something in return. Consideration means something in return. Once they promise, when they comes in relationship, what is happening? There is a consideration there. Here's a consideration like they take care of each other. Okay, and taking care of anything they want. Okay, so this kind of consideration. Okay, and after that, once a promise having a consideration, it is an agreement. Okay, and when the agreement, okay, when they an agreement having an enforceability by law, it is a contract. It is a contract. So the agreement enforceability means that is a registered your marriage registration. In that case, what there comes into the contract, that they are a husband wife. So this is in this kind you can remember this. So offer plus proposal, then this is a acceptance. After that acceptance, this is first. Okay, this is second, then it become a promise, then a promise having a consideration, it's a agreement, and after the agreement is enforceable by law, then it is a contract. So C, yes, option number A, CEBAD. Okay. Yes. Now the statement is given for the LLP is not true. Okay. LLP, in case of LLP is not true. There must be an at least one designated member. At all the time, designated member do not have the same right, and designated member do not have the same right and duty as the other member. There is no specific requirement to having any number, any non-designated member, and the limited liability partnership may be established such that all the members are considered to be designated member. What is it? What is the question is limited liability, but it's related to the designator. Designated member. Now the question is, what is a designated member? Designated members is the person who is having the same kind of right, same kind of duty, same kind of authority to be the other, like a other member. Okay, so the first thing, that is the first statement is given, that is there must be at least one designated member. No ma'am, at least having the two designated member, and from that two designated member, one designator is must be resident of India. Okay, must be resident of India. Clear? And designated member do not, yes, they do have the same rights and duty as the other member. So these two options we have already, this is a not true. Okay, after that After that, there is no specific requirement to have any designated member. Yes, this is true. There is no specific requirement is given for the non-designated. Non-designated designated means a simple member. Okay, general member. Now, the limited liability partnership may be established such that all the members are considered to be designated. Yes, yes, yes. So this is also true. So option number A and B. They consider all the member act like a designated member, because a designated member, that means that they having a duty and a responsibility. So in the LLP, they establish in such that all the member considered to be designated member. Okay, this is an important point that you have to be keep in your mind. Okay, so the option number A and B is not true. Clear? Now, who are not eligible to get information under the RT Act from the following? That is a corporation, association, company, citizen, and legal entity. Who is not eligible? Who is not eligible to get information under the RTI? Who is not eligible? So, you know that RTI, the right to information, is applicable only and only to the citizen person. Only and only to the who is a citizen of India and who is a person. Okay, not any kind of company, not any kind of a corporation, not any kind of association, not any kind of legal entity. But there is one exception. If one person is is a leading, okay, or if a person, what I'm saying, having a authority, or he representing, sorry, the if the person representing whole of the corporation or association group, or the company, in that case the person, those person, that person is eligible for the right to information. So who is not eligible? So A, B, C and E is not eligible. A, B, C and E. Okay, so option number 2 is right over here. Yes. Now the sequence for the copyright ecosystem of the literally creating the in India. So the Copyright Act is, this is an important Copyright Act in 1956. What is it? Copyright Act is 1956. So Copyright Act is 1956 is for the sequence. You have to arrange in sequence. So first thing, you need a content. Okay, need a content. After the content, you have to communicate that content with the public. Okay, and after that, once you uh, do it once you do it, after that you have to the assignment of that copyright, you have to prepare the assignment. First thing, you have to collect the content. Okay, the first one. After that, you communicate with the public. Okay, that means you are collecting information in the simple word. And after that, you have to assignment, you create an assignment of the copyright. And after that, there is a copyright transmission from one person to another. Okay, there's a transmission. And after that, you relinquish the rights. That means fifth one. So C, yes, where it is C, yes, C, A second, okay, and the B, yes, B is third, and the fourth one is E, and the D, okay. So the second option is right. Okay, how do you remember it? You have to collect the content. After that, you communicate with the people. That means you are collecting the data, and after the communicating that, what do you do? After that, your assignment, you preparing your assignment, and after you prepare your assignment, there is a copyright transmission. Last one, that is a recognition, that is a copyright. Okay, clear. Next one, the question: the contract is a discharge by the superviling the impossibility under the which of the following situation? The first one, destruction of the subject matter, death of the disabled parties, and the rescission and the remission, and according with the satisfaction. Clear. So here, contract is discharge. That means it's a question of the discharge of contract. So what are the condition when the contract get discharged? So there is the condition when it is the contract going to be discharged. So what is the meaning of the discharge of contract? Discharge of contract means a cancellation of a contractual relationship between the parties. Clear? Okay. So here, what are the condition when you are the contract going to be discharged? Okay, so discharge of a superior impossibility when the destruction of the subject matter, if the subject matter going to be destroyed, if the date of the party or the disability of party, okay, and if the non-existence or a non-occurrence of the particular state of the things. Okay, what is it? Particular state of things, if they are decided to if the mangoes is grow in the farm, so in that case he can purchase that mango. Okay, a person purchase from the B, but the mango is not growing in that farm. Okay, not will not be go. So what happened, he will not bound it to that contract. Okay, so this is an whatever, this is an the non-existent and non-occurrence of the particular state of thing, and the date and incapacity of person of services. Yes, if they, if any person is that or disable, either he's not able to pay, in that case also the he's discharged from the contract. And change of the law shapes, any kind of changes in the law, any kind of shapes in the person of statutory authority, or outbreak of a war, outbreak of war. In case of outbreak of a war, there also a contract going to be vanish, or you can say you can come, the party going to be discharged from this contract. So there is a only two things which is comes, that is A and B. So second is the right answer. Yes. So thank you so much. Here we are completed our 25 questions. Okay. So thank you so much. And do your study very well. Hope you are doing very well. So see you soon.